Yasir Darraji was charged and convicted following the brutal passing of his wife in February of 2020. She was found in a burning vehicle and it was determined that she had been strangled. They had 2 children together and had immigrated from Iraq to Spokane in 2014. The state argued that Yasir felt disrespected by his wife when she adapted to her new life and became too American. She changed the way she dressed, she started going out, and she converted to Christianity. Within the Iraqi community, there were rumors she cheated and had become pregnant. Yasir is now appealing his conviction, arguing the state committed prosecutorial misconduct by introducing inflammatory and irrelevant evidence about Islamic beliefs. He argues this was done to trigger anti-Muslim bias within the panel of jurors. Let's take a look at the arguments.
Good morning, Your Honors. Jessica Wolf from the Washington Appellate Project on behalf of the appellant Yasir Darraji. I'd like to reserve 5 minutes for rebuttal.
Okay.
I'd like to focus this morning on the issue of prosecutorial misconduct. Following September 11th, this country was gripped by Islamophobia. Muslim countries were portrayed on the nightly news as barbaric and backwards. Muslim men were stereotyped as terrorists and religious extremists. Muslim women were in turn seen as forcibly veiled, as child brides, and as victims of honor killings. By contrast, America was portrayed as a crusader of democracy and Judeo-Christian values, the land of the free. These tropes are now entrenched in the national consciousness. For example, Trump was elected in 2016 in part due to his promotion of a so-called Muslim ban. Ibtihal Darraji's death was investigated as an honor killing from the outset, based solely on her association with the Iraqi refugee community and a detective's reading of a Wikipedia entry.
Was there some evidence that this was an honor killing?
No, Your Honor. The theme of an honor killing was one that was manufactured by the prosecution. And although the prosecution attempted multiple times to elicit that kind of evidence from its own witnesses, it was unsuccessful in doing so.
Do honor killings exist?
Yes, Your Honor.
Do they exist in the United States?
I assume that they do. I'm not familiar with.
Okay, if an honor killing occurs, is it proper for the state to use that as a theme?
Yes, Your Honor. So if there had been evidence in the record.
Well, what about the evidence? There was a discussion between the defendant and I believe a friend about a trial occurring. There was a trial back in. Trying to remember. I'm sorry. Iran or Iraq?
Iraq.
Iraq. Sorry. There was some discussion about that because what the victim was accused of, at least, arguably would warrant an honor killing. Whether there's some sort of discussion the defendant had with a friend about a trial occurring back in Iraq?
If Your Honor is referring to the discussion of tribal resolution,
Yes.
that I think is a separate. There was no discussion that she would be killed for her behavior. There was no discussion that this was an honor killing. In fact, none of the witnesses used the words honor killing. So, I think it's very important. This is a really fact-specific inquiry.
Right. And so, Ms. Wolf, to narrow it down a little bit, the witnesses did say that part of his motivation was that she was behaving in a manner that he felt was inappropriate and disrespectful, correct?
So there was quite a bit of testimony about the community's reaction to her behavior as it pertained to drinking, to going to clubs, to dating. And we would posit that that is behavior when a divorce occurs in a small knit community, that is not, that those are things that would cause that community to talk about and gossip about, and that it was not specific to the fact that this was a Muslim community.
So was there any evidence that Mr. Darraji himself felt that her actions were inappropriate?
So the only thing that we like, if the state's evidence is to be believed, they claimed that he told one of her friends, she was the one who cheated on me first, that this was really about infidelity. And I want to go through the prosecutor's closing statement and kind of go line by line, and we can talk about the evidence.
Did Mr.
that
Darraji also contact his ex-wife's parents and complain about her?
No, he contacted the parents of her friend,
Okay.
I believe. So I just want to go through the closing argument. So in the very beginning, the prosecutor starts her closing argument by pointing to the age of Mr. Darraji when they got married. She said she was 14 or 15 years old. Not necessarily relevant to the facts of the case, not necessarily relevant to the murder charge, but focuses in on her age. This was a child bride. This is the beginning of the theme. Then says, Miss Darraji misunderstood the freedoms of the United States. She started drinking, she started driving, she started working, she started wearing the clothes she wanted to wear. She wore shorts, she wore skirts. She misunderstood the freedoms. The only evidence about Mr. Darraji referencing freedoms was about her economic freedoms, and that was done in a police interrogation in which he said she was told if she got divorced that she would get alimony payments, she'd get child support payments, she'd get the house, she'd get the kids. There was no evidence that he ever said she was taking advantage of American freedoms by driving and working. In fact, the only testimony that came in about her driving was that she had gotten her permit before they had gotten divorced and was learning how to drive. There's no evidence in the record that he didn't want her to drive. There's no evidence in the record that he took issue with the way that she was dressing. And in fact, the only reference that I could find in the record to shorts was when the prosecutor asked a witness, was she wearing shorts? Was she wearing skirts? And the witness says, I don't recall if she was wearing shorts or not. So, I mean, this theme that she was driving, that she was dressing inappropriately, was really a theme that was manufactured by the prosecution in its theory of the case. And unfortunately for the prosecution, that evidence didn't come out at trial, but that didn't stop them from hearkening back to this theme of her being this oppressed Muslim woman in their closing argument. You know, they talk about the testimony from Mr. Nahi, which was only admitted to show whether her fear was reasonable for the harassment charge, a charge the state now admits is not supported by substantial evidence, and said, you know, Mr. Nahi testified that the rumors were spreading about her drinking, her dancing, her nightclubs, her driving, her jobs, her Christianity. All of that is a death sentence in Iraq, maybe here too.
But isn't it true if Mr. Darraji was spreading these rumors, that it's evidence that he was, I mean, that this type of behavior would bother him?
So this evidence came in to show her fear for the harassment charge,
Okay.
not
To show him.
to show motive for
Right.
the murder. And I think that's a very important distinction.
Yes.
When they added this charge, the defense actually pointed out, I'm concerned that you're using this harassment charge to get in this other evidence that wouldn't otherwise be
But defense never
admissible.
asked to sever the trial, even though the judge suggested it.
Right. And this evidence, you know, there was an objection after the testimony came in, right? He waited until the jury was excused and then said, you know, I'm really concerned about this testimony. The jury's actually given a limiting instruction saying you're only supposed to be considering this testimony for this particular charge. But then in closing argument, they suggest that it's a motivation for him to kill her, right? They talk about, you know, her Christianity at great length. And they say in closing argument, that was the beginning of the end. Her conversion to Christianity, her working at the Union Gospel Mission, that was the beginning of the end. There is no evidence in the record that her conversion to Christianity was upsetting to him specifically, that he said, you know, I wasn't upset. I just asked that she didn't take the kids to church with her. There's one comment where he says, you know, I saw that she was a non-believer. They had 3 years to investigate this case. They had access to all of their telephone communications, their text messages, all of the social media. If that's the most that they can come up with, this theory was not substantiated by the evidence. I want to go through the Bagby factors, the 4 factors from Bagby, which are the content and subject of the questions and comments. So the themes that they are eliciting: Christianity, you know, her not covering her hair, I think particularly the use of the word Americanized. Was she Americanized? The prosecutor says this in the opening questions, two different witnesses about this who both say, no, she wasn't becoming Americanized. That's not what we thought about her. But I think that the prosecution is using this term repeatedly in questioning, in argument, to signal to the jury, Mr. Darraji was Americanized, Mr. Darraji is not. Ms. Darraji is Christian, she is like us, she is Americanized, she's taking care, like she's taking advantage of her American freedoms. Mr. Darraji wanted to stop her from doing that.
Ms. Wolf, you would agree, though, that if there was evidence to support this theory of the case, then it would be proper argument and it would be proper evidence.
Absolutely. As I responded to Judge Fearing,
Okay.
if this had been an honor killing, yes, it would have
Well,
been
not even
admissible
an honor
evidence for
killing,
motive.
You know, technically, but just that he felt disrespected by her based upon her actions, that it would be relevant.
Yes, and I would also posit that there are plenty of relationships where disrespect is an issue. It doesn't mean necessarily that it's a religious issue, that it's an us versus them.
Okay, and that raises another issue for me, because you just assumed that Zamora and Bagby's race-based prosecutorial misconduct applies to a religious-based prosecutorial misconduct, but you don't provide any analysis on that.
So I do think there is some analysis. I see that I'm into my rebuttal time, but I do want to answer this question. There are law review articles cited in the briefing that talk about the racialization of Islamophobia and how we cannot separate race and Islamophobia, that they intersect, and that we know that the objective observer standard applies to race and ethnicity. Ethnicity includes religion.
I understand, well,
It includes religion, it includes language,
where
it
do you
includes...
get that from?
That's the definition of ethnicity, right? It's about a cultural context. And I don't think we can separate race and Islamophobia, particularly in this specific context,
Okay.
right? When we talk about the image of the oppressed Muslim woman, the image of the oppressive Muslim man, most Americans have a very specific image in their head of what those two people look like. And it is a race-based image.
Okay, thank
Thank
you.
you.
You were starting to give a list of what you thought to be race-based, religious-based comments by the prosecutor. I'm not asking you to do that now, but when you return to the podium, I'd like for you to continue through that list.
And just to make sure I understand, you want me to articulate a list of the specific references the prosecutor made during questioning and during closing
and
argument?
whether or not there was evidence to support that.
I'll continue on that thread, Ronnie.
Thank
Thank you.
Lundgren?
Thank you, Your Honors. May it please the court. Alexis Lundgren on behalf of the state. Your Honors, this was an honor killing, and I think there are two parts to the defense's argument. And one seems to be that there was some problem with the investigation and that the investigation itself did not show or was only based on a Wikipedia and research of honor killings. And I think that's not properly before the court because the investigation was never challenged, and the prosecutor relied on all of the police reports and all of the investigation. They investigated and interviewed all of the witnesses almost all of the witnesses in this trial were from Iraq, were refugees from Iraq. And so the law enforcement, when they were investigating this, was talking to those witnesses. So the idea that this is fabricated from the point of the investigation, I don't think is before the court, and I don't think is supported. But in terms of race-based prosecutorial misconduct, I think one important point is that the defense offers the argument that Mr. Hamid Nahi's testimony about the death penalty was only admitted to show Mr. Raji's fear and related to the harassment charge. That's not accurate. In motions in limine, the state moved to admit cultural testimony about the differences in Iraqi culture. And Mr. Cossey, trial defense counsel, objected on the grounds of foundation. He said that it wasn't proper for him to object on to the content, but that he didn't know how somebody would be able to testify specifically to the region and whether the cultural norms in the particular region of Iraq that Mr. Darraji was from was the same as where Mr. Nahi was from. When Mr. Nahi testified, he first testified that converting to Christianity and engaging in dancing and relationships with other men and a variety of the behaviors that Mr. Raji was rumored to have been engaging in, that those in that particular region of Iraq would be considered, would justify her death.
Ms. Lundgren?
Yes,
and
Your Honor.
I understand that, and he's testifying generally.
Yes,
But
Your Honor.
don't you agree with me that there needs to be additional evidence that ties those generalized statements to Mr. Darraji specifically? In other words, to show that he's adopted that?
Yes, Your Honor, absolutely. And my point there was only to say that there was that testimony that this was a cultural thing from the region, and that was not admitted solely for the purposes of her fear. Mr. Nahi later, I think in the next paragraph or on the next page of the transcript, said that that Mr. Raji was then afraid because
But where's the
because she was
evidence
engaging in those behaviors. Whereas
that Mr.
yes.
Darraji said, yep, that's me?
So it's important to look at what Mr. Darraji has done is look through each individual piece of evidence and try to discredit each individual piece of evidence on its own grounds. And the court needs to look at the totality of the circumstances. So there are statements from Mr. Darraji himself that she understood her freedoms incorrectly. Why would she need freedom if I didn't put boundaries on her? And this is related to economic things, but it was also related to his interview with Detective Turman, where he said that part of the reason for the divorce was that she understood the freedoms incorrectly. That combined with the other evidence goes to show he's upset about these things. He states, I heard she became a believer in God. That's what I heard. And that was something that Mr.
A believer or an unbeliever?
An unbeliever. I apologize, Your Honor. An unbeliever in God. And that was something that he wanted Miss Suede to hear at that hookah bar to show her that Mr. Raji was not behaving how he would like her to behave. During testimony, he said, but thank God I am a man. Miss Zainab Jamil said, Mr. Haydar Hussein said that Miss Ibtihal or Mr. Raji drinking at the nightclub was not part of their culture or traditions. He does say that I'm not saying it's drinking and going there is unacceptable, but our traditions as Muslims and customs, that's not part of it. And then he had to cheer Mr. Darraji up because Mr. Darraji was in a mood because of the behaviors that
and he told Mr. Darraji this, and this upset Mr. Darraji. Is that the evidence?
I don't know that Mr. Hussein was the one who told her, but they were conversing about the behaviors that Mr. Darraji was engaged in, and this upset Mr. Darraji. And then a large amount of testimony came in from Miss Suede, and she said that Mr. Darraji was saying that Miss Darraji was not a good person. She was a bad person. They got divorced because she wanted to live her life. Now she's drinking. She goes out. She meets a lot of guys and all that stuff. It's a bad thing in my culture. We don't see a girl do all that and drink and smoke and do all those things. It's not good. And Miss Suede also says Mr. Darraji is telling her friend, telling her that she should tell Mr. Darraji that she should respect her, that she knows he gets really mad when people ignore him or leave him.
So let me ask you something here, because in a domestic violence murder situation like this, a lot of times we have evidence where the defendant is motivated by, you know, actions of the other, the deceased person. And we say, well, you know, he felt disrespected, or he, you know, felt slighted, or he was jealous or angry or something to that effect. What does the cultural aspect add to that in this particular case? Because a lot of times these cases go through without that additional element on top of it.
And Your Honor, it was relevant in this case because it was his motive. This was a circumstantial case. And I think one of Your Honors referenced some threats that or not a threat, but he said it wasn't a threat, but there were messages, voicemails that he sent to Ms. Darraji's parents in addition to Ms. Suwaid's mother. Ms. Suwaid's mother, the conversation was about Ms. Suwaid's participation in the Winco fight with Mr. Al-Karawi. But Mr. Darraji sent multiple messages to Ms. Darraji's parents telling them to call her off, and that if she didn't start behaving better, that she would get the lion's teeth. If you pull the tail, you get the teeth.
That was a phrase I was referring to earlier, some sort of a communication along those lines.
Yes, Your Honor.
And that was to her parents in Iraq.
Yes. And another point that I think is really important in this case is that this theory was also relevant to the defense's alternative suspect theory. So the theory was that Mr. Saad Al-Karawi was the murderer, and defense counsel spent a lot of time pointing out some of the suspicious things that had gone on with Mr. Al-Karawi that night. And if Your Honors would allow me to just read a small excerpt of Mr. Cassie's closing argument, he said, "But what's interesting here is they exclude him early on," speaking of Mr. Al-Karawi. "Detective tells you they're not worried about him. We don't think he was a part of this, even though they try to minimize that fight. That fight cannot be minimized. Everything that the state has said about him and his actions was she provoked him, she dishonored him," speaking of Mr. Darraji. "Therefore, he reached a boiling point that Monday night before she died to reach out and kill her. It's all important about the clothes and the drinking, and all these are a big deal to show why she had motive. But yet, Saad can be beaten up by two women a few weeks before she disappears, and that's something not to be considered very strongly by you as jurors." And so the theory was that Mr. Al-Karawi had been assaulted with possibly an ice pick and been called a shoe, and in public at a Winco just a week before, sorry, not a week, I believe it was January 9th, and she was killed on January 30th, so several weeks before she died. And this was central to the defense's theory of defense, that these types of behaviors from a woman would be perceived in a specific way and could motivate this type of retaliation. And so it applied for Mr. Darraji. It also applied for Mr. Al-Karawi. And so I would say that this case is very unlike Zamora, unlike Bagby, unlike Tarrar, because these were facts produced in the case.
You're saying these facts could have benefited this alternate suspect defense too?
Yes, Your Honor. Yes. And it was a legitimate alternative suspect theory. It's one of the stronger ones I have seen. Mr. Saad Mr. Al-Karawi had a number of, had purchased cleaning supplies and had gloves in his vehicle. He had purchased the cleaning supplies at two different places that night. And the vehicle that Ms. Darraji's Darraji's body was found in was a block away from his apartment. So the idea that there are these honor themes going on was equally relevant to the state's case as to the defense's theory of defense.
I want to ask you some questions on some other topics.
Yes, Your Honor.
Who was the victim who suffered a foreseeable and destructive impact that was the basis for the aggravator?
Your Honor, the prosecutor argued it was the children, the friends, the first responders, and then the entire community.
And was there evidence that any of those persons had suffered a foreseeable and destructive impact?
Yes, Your Honor. I believe with respect to the children, there was there was the basic evidence that their mother was gone. Also that there was
Is
evidence
the
that
fact that
she,
your mother gone, is that sufficient evidence of a foreseeable and destructive impact?
no, Your Honor, but there was also evidence that both the son and daughter had come out while Mr. Darraji was strangling Miss Darraji and had possibly seen that. You'll also see there is a large outburst when the son is called to testify. And I think that can be considered by the court as to the impact. So that's the basis for that.
How about the impact to the others?
For the first responders, I think many of the first responders said that this was one of the most traumatic cases they'd responded to. They initially responded to a burning car and didn't know that there was a body in there. And when they pulled the body out, it was so rubbery from being burned that they didn't even know if it was a real person. It was, they thought it was a mannequin at first. And I think throughout the entire trial, both defense counsel and the prosecutor talked about how emotional this case was, and that it would impact everyone who had been a part of the trial. So yes, I do believe that there was evidence of those things. I think the saying that the community impact, that is too broad. That is too broad on that aggravator.
How do you distinguish this trial in terms of speedy trial from State versus Denton?
Well, okay, so there are a couple of things. The first thing is that trial was never set outside of speedy. So it was, and I would like to correct one error I made in my briefing. On that first contested continuance, I claimed that the continuance was from January 21st, 2021 to February 1st. It was from January 25th to February 1st, so that's only 7 days. And then the next continuance was 49 days, so that's 56 days. So it was never set outside of speedy trial, even if Your Honor believes that there wasn't sufficient evidence and there wasn't good cause. It's also under State v. Walker, this claim is not preserved. This claim was waived by not objecting within 10 days of trial being set and within the time that speedy had not expired. So does that answer Your Honor's question, or would you like me to?
Well, let me ask you a more specific question. Has the need to translate documents ever been considered good cause for a state's request for a continuance?
I am unaware of any cases where that is the case. I think this is different than Denton because in Denton, it's a statewide problem and it applies to all cases where there's backlogs related to tox lab results. And in this case, the prosecutor had a funeral the week before the trial. There were very extensive documentation. All of the attorneys talked about how complex the discovery was in this case. And they were relying on one single FBI translator who could translate. They documented that they were unable to use other Arabic-speaking individuals in the community because of the nature of the case and the potential contamination of witnesses.
Did the FBI translator have a backlog of work?
It doesn't appear to me from the record that it was a backlog of work, but it was thousands of pages of documents and voicemails. And my understanding from the record was that took an extensive amount of time.
Has the need to execute additional search warrants ever been considered good cause for a state's request for a continuance?
Not that I know of, Your Honor.
Thank you.
Yes, Your Honor.
I have just one question
Yes,
here. The standard for race-based misconduct is pretty low
Yes,
in
Your Honor.
this case. And channeling Judge Sidaway here, how do you think the Supreme Court is going to consider this case?
Well, I think co-counsel has admitted that where the evidence supports that it is an honor killing and that's a motive, that is proper. And again, I would point the court to the fact that Not only was this admitted properly to show motive in a highly circumstantial case to show that Mr. Darraji was indeed the person who killed her and his intent to strangle her, but also crucial to the defense's argument for an alternative suspect. I think the court would affirm.
Thank you.
Thank you, Your Honor.
Thank you. Rebuttal now?
I want to make a few points to Judge Stopp's question regarding the intersection of race and Islamophobia. I would point the court to the Chowdhury article and the Baidoun article, Race, Craft, and Identity in the Emergence of Islam as Race, and Faith and Whiteness, Free Exercise of Religion as Racial Expression.
Thank you.
Those are both cited in the opening brief. I also want to talk about this alternative suspect theory and why the honor theory and this gendered theory, the alternative suspect theory was that this other man was assaulted by Ms. Darraji and her friend. That would be motive in any case, regardless of the cultural context, regardless of the cultural background of the parties involved in the case. The fact that he was hit by these two women would give him motive, regardless of the fact that he is a Muslim man. It's not relevant to the alternative suspect theory. This idea of an honor killing is not relevant.
The witnesses or the other suspects' adoption of a particular cultural doesn't tend to increase or decrease the motivation. I'm sorry, I'm not articulating my question very well. But I guess what I'm trying to say is I get what you're saying, but this additional factor may provide more evidence.
Well, and the state tried to elicit that and failed, right?
Okay.
They asked Ms. Sawad, who was one of the women who assaulted the alternative suspect, is this problematic for a man to be assaulted by women? And she said, no, they would probably think he deserved it.
Okay.
So the fact that the state is still adhering to this idea of an honor killing, of this being about a gendered conflict and a religious conflict, today, I think that underscores the problem here, right? And I wanted to go to Judge Fearing's question about what evidence they relied on to try and bring this honor theme to the forefront, and I want to show that it's not supported by the record. Okay, so they talk about at length her conversion to Christianity, right? They bring this up with 4 different witnesses. They ask about her attending church. They have her former boss come in and testify about how she prayed at work. She did devotionals at work. They talk about her not covering her hair. They ask one of the witnesses, who's also Christian, is this something that would be frowned upon if she did it in Iraq? And the witness says, I can't answer that question. They ask, did she only start converting to Christianity, going to church after her divorce? And her friend says, no, she was going before. There's no evidence in the record to suggest, except for the fact that he doesn't want her to take the kids to church, and the fact that he says she's a non-believer. The singular statement, there's nothing else in the record to suggest that this was a primary issue for her. There is this theme of becoming Americanized. That is the word that they use repeatedly, even though the witnesses don't agree with this characterization. And it's referenced in the opening, and they reference misunderstanding American freedoms. This theme comes up again in the closing. Again, this is what Bagby warned us about, this us versus them dichotomy. They said these kinds of subtle appeals to bias are really dangerous, that we are using coded language to signal to the jury the otherness of the defendant. Driving or having a car, there is nothing in the record, even though the state brings this up repeatedly, to suggest that Mr. Darraji did not want his ex-wife to drive a car. She would come and pick up the children in the car. He actually testified she was learning to drive before they got divorced. Dressing differently. There is one witness who says she started to dress a bit differently after they got divorced. But when they ask about specific clothing choices, did she wear shorts? The witness can't remember. And they reference the shorts in closing argument. It's not supported by the record. So I think, and I also want to talk about this photograph of the daughter that comes in for no apparent reason, according to the state. I think there is a very clear reason why this came in, and it is because the daughter's testimony and presentation in court did not comport with the state's theory that Mr. Darraji was controlling the women in his family and in his life, right? The testimony from the detective was, I saw how the daughter came in yesterday and testified, and the implication from what the detective is saying is that she didn't have her hair covered, she wasn't dressed traditionally, she didn't look Muslim. And he said, so this picture really stood out to me because in all the other pictures I've seen of the daughter, she isn't wearing a hijab. And I think that the purpose of introducing this photograph was to try and inoculate against the daughter's testimony that my father supports me in anything that I want to do, was to inoculate against her presence in the courtroom, uncovered or dressed in however it was that she was dressed that didn't appear to be Islamic on its face. So I think that when we look at all of these pieces together, we simply do not have an honor theme that is supported by the evidence. What we have instead is a run-of-the-mill domestic violence case about respect, about infidelity, about her going out and being with other men.
Let me ask you a question then about that,
Yeah.
because one of the issues is this last voicemail that she leaves on Darraji's phone or something she sends to him. It was a voice message. I don't know exactly how it was done, but she insults him. And I think you challenged that voice message in your briefing, but isn't that evidence to show motive?
So the voicemail, I think this is very important. The voicemail only came in to show her subjective fear of him. It's odd because it's her threatening him, and then they introduce it to allow her the testimony that, they allow it to allow testimony that she said she was really afraid that he didn't respond to the message. And that made her scared.
Tend to disagree, and I read through the record again last night, and I think they were introducing it for two reasons. That was one of them, but also to show motive. And could it be introduced to show motive?
Right. So let's look at how the prosecution characterizes that voicemail in its closing argument. I'm a little confused about whether I'm out of time.
You are.
Okay.
It's okay. We let everyone
We're just
ask
okay.
questions
All right.
and answer them.
Okay. I appreciate that, Your Honor.
Thank you. For asking.
So let's talk about how this is characterized. So the prosecutor says in closing argument, when he receives this voicemail, he's crying on the phone, so upset, can't believe she would say these things to me. She's questioning my honor, my masculinity. I am a man. This is it for him. This cannot go on. Ibtihal cannot shame him like this. She cannot humiliate him and disrespect him. That was not the testimony about the phone call. Mr. Darraji and the friend that he called, Khulud, both testified about this phone call. And Khulud's testimony was he was crying and he said, why would you want me to get back together with a woman who treats me like this? It had nothing to do with she's questioning my honor, my masculinity. I am a man. That is a manufactured theme by the prosecution.
And I get that. Separate from that, though, is the voicemail message evidence of motive?
So it didn't come in as motive, is my reading of the record. It came in for the purposes of showing her subjective fear to go to the harassment charge, which again, the state has now conceded is not supported by the record.
Did the defendant ask for a limiting instruction?
Yes, there was a limiting instruction. I can actually give Your Honor the site if I can.
Well, I don't want you to waste time.
Okay.
If it's not handy, we can find it, or you can send us a letter with it later.
Yes, there was an instruction that certain evidence was only admitted to show her subjective fear. And again, this evidence was admitted to show that when he did not respond to this message, she became fearful. So it also wasn't relevant to the harassment charge, which is going into the evidentiary issues, but there's no connection between this voicemail and his statement to Gabby that she cheated on me first, I'm going to kill her. That was the charged harassment. So it shouldn't have been admitted because it wasn't relevant, but it was only admitted for this purpose.
I guess, yeah, never mind. I just answered my own question.
Was the evidence so overwhelming even outside what Mr. Darraji considers to be race-based, such that we should affirm, and that overwhelming evidence is principally the fact that the cell phones of both Mr. and Mrs. Darraji are going together during the likely time of the murder?
The Supreme Court has been very clear that race-based prosecutorial misconduct is per se prejudicial, and this court does not need to engage in any kind of prejudice analysis.
Do you have any argument that's not overwhelming evidence?
Your Honor, my position is frankly that it doesn't matter when the state engages in this kind of prosecutorial misconduct, that it undermines our trust in the entire judicial system, and that is the reason, as this court has pointed out numerous times today, that the bar is so low. It's because we're trying to eradicate racial injustice and racial inequity within our criminal system and our justice system writ large.
Following these arguments, the court found no prosecutorial misconduct. Because Yasir admitted his disapproval of his wife's behavior, which he described as culturally motivated, the argument was not improper. The court affirmed his conviction for her death, but reversed his conviction for felony harassment based on insufficient evidence. Should jurors be permitted to hear arguments about the accused's religious beliefs? Let me know what you think in the comments below. And if you like this video, please hit subscribe for new arguments every week.